only about 40 odd minutes with 3 speakers, so I will try to limit my presentation. And thanks to Yatin that he has given a brief overview of the TTOs in the Lehigh University. So I'll be restricting, or I'll be focusing only on the Indian perspective of the TTOs in educational institutions. Role of TTOs in educational institutes. As Yatin has already mentioned, that it's to educate and create IP awareness amongst the institute, coordinate the process from the stage of IP evolution to commercialization, starting from the inventor student to the professor to the HOD and the TTO office, and interactions with the IP attorneys. Guiding student innovation to obtain IP protection by interacting with IP attorneys, organizing programs in association with companies to showcase the research, development and creation of the technologies by the students, setting up IP management, research consultancy and incubation centers to see to it that they get funding and therefore commercialize the said technology. The first and foremost process in commercializing is to create IP awareness, then to identify what are the IPs, providing invention disclosure forms to the students to see to it that all the inventions are documented, assessing the potential of the intellectual property. The TTOs may conduct prior art searches, patentability opinions may be taken to evaluate whether the IP should be protected or not, and if yes, how to file and obtain protection. Technical marketing and licensing are other commercialization processes. Once they have decided as to which entity is to be once it is decided that which entity they need to enter into, then the terms of the license or the transfer need to be negotiated. Having said that, I will now touch upon the issues that are in place in all these institutes. Now, the systems that are there in the Indian scenario keep on adding up the delays in obtaining the protection. Right from the nascent stage of how the invention is created, that is, right from the student to the interaction with the professor, then the HOD, and then the technology transfer office. All these processes eventually add up into delays in obtaining the protection. Unless the TTO in India instructs its attorneys, nothing moves forward. The tussle for ownership or inventorship is another concern. I must share, in one of our cases, the inventor, when he approached us, he told us that his guide was wanting to include his name as one of the inventors, which obviously cannot be the case. But yes, there have been such issues in the Indian institutes which we need to tackle. The revenue sharing is another aspect which is something which we need to grapple upon. Leakages are caused when the student or the professor interacts directly with the company without involving the technology transfer offices. The leakages can be in the form of confidentiality being violated. Today, not many TTOs in the educational institute act as TTOs in the correct sense. What is happening is they are mainly IP departments, but they are not TTOs to negotiate the transfers. As Yatin was mentioning, that in his university, the effect of a TTO is everything from A to Z, that is from initialization till the commercialization. But unfortunately, not many TTOs in India are prevalent in today's age. And we are hoping that on the basis of whatever is happening happening across the world, the Indian institutes also take into consideration these aspects and dwell upon these. The DPO today is just the face for the IP attorneys. So what happens practically is that the IP attorneys don't interact with the inventors. Many a times it so happens that when we are wanting to interact with the inventors, the DPOs come into picture. The DPOs then share the data directly with us. We don't interact with the inventors directly, and eventually what happens is the specification which is filed in the patent office is not the correct specification. So eventually what happens is the institute and the inventor does not get the protection that is eventually wanted for. Sponsors. Now sponsors of tech fests, they aren't wished to own certain inventions, and the institute may succumb to this demand for the exchange of sponsorships. Now these are some of the issues that we have faced with institutes in India. These are the types of transactions like funding, investments, technology collaborations, technology licenses, whether it's an exclusive license or a non-exclusive license, whether the technology license is directly or through agents. There can be acquisitions as well. But to have all these transactions, the first and foremost step is to value the technology. We have also seen startups emanating from these institutes. Startups in various technologies emanating from these institutes to have companies wherein investments can come up in these companies. There have been instances wherein entities have acquired these startups to commercialize the said invention. These are some strategies that the DTOs, at least in India, can consider. At the time of inception and development, the invention needs to be documented. We need to see to it that the disclosures are kept ready. Experimental and research data is recorded. The inventor details are maintained. The DTO needs to see to it that the assignment from the inventors is taken, otherwise at a later stage there may be some difficulty. Confidentiality agreements with receivers of such information need to be entered into. At the time of filing, the DTOs should ensure that they should tell the student community to avoid any disclosure or publication before the filing of the said patent application. They can decide whether novelty search or patentability search or opinion should be taken. They can also decide as to whether a freedom to operate opinion needs to be taken at that stage, depending on the commercial viability of the said technology. When the DTO is deciding for the protection, they should also decide what type of protection is available. Many a times for products that there may be protection available under the Patents Act as well as the Designs Act or the Copyright Act. So there may be overlapping protection available. So the DTO needs to decide and finalize on what protection is the best available for the institution. At the time of negotiations and for joint developments, the confidentiality agreements and other agreements need to be entered into. Whether it's an assignment or license, depending on the commercial terms, needs to be decided. What is most important when you are entering into a technology collaboration or licensing is the ownership of the said IP. Whether when the company is having an exclusive or a non-exclusive license, the ownership of the improvements or ownership of the IP, depending on whether there is a stake which is being taken by the company, needs to be decided at that stage itself. Whether it is the company or the institute or both. Now, strategies for the DTO at the time of filing, we need to decide whether it's a provisional specification or a complete specification that needs to be be filed, depending on what is the stage of the invention. If the subject matter is a non-patentable subject matter, then you can also decide whether you would want to explore foreign jurisdictions. And if that be the case, then a foreign filing license needs to be obtained in India. Once the provisional or the complete specification is filed, the TTOs can decide whether to leverage the patent pending. Now, leveraging the patent pending can be many folds. One of them would be taking in funds or investments into the said company. But before that, a prior due diligence or vendor diligence could be conducted to ascertain what is the worth of the technology. Many a times what happens is institutes or companies go in for an investment, and at that time they realize that the patent that they had filed is already infringing on someone else's patent. The patent that they have filed is already a prior public art, and therefore no exclusivity can be granted to that company. So therefore, before even wanting to get into the investment and funding, one needs to ascertain as to whether the said technology that is being commercialized, what is the worth of that technology. At the time of the funding, one needs to be clear as to what is the ownership that the company is going to take and what is the ownership that the institute is going to have. Because many a times what happens is, at the time of funding, you dilute your ownership and you need to see to it that that is taken care of at the first instance itself. So the advice is that whenever a TTO is interacting with any of these companies for funding, MOU is first initiated and thereafter definitive agreements are entered. When the technology is being assigned or being exploited, one needs to also understand that, as I had mentioned, that there may be other overlapping IPs, and that is the reason the rights to own other unrelated IPs should be kept with them, and only those rights should be assigned or transferred, and therefore no blanket assignments that all the intellectual property in relation to the said product or invention is assigned to Accenture. Needless to mention that the revenue structure needs to be tax efficient. Since it's a TTO, all the proceeds would go towards the research and development, and it's not a company, so therefore it's a non-profit organization. So one needs to understand that all the proceeds that are coming from the commercial exploitation needs to go towards the research and development, so that they could use the same funds into a different research. Lastly, the innovators need to be rewarded. We know that under the Indian Patent Act, the inventor's name now can come under the patent certificate, but other rewards for the innovators should also be